Paul has 26 years of financial, estate, and charitable planning experience as a certified financial planner. His background includes 10 years in financial services before he pivoted to the higher education community, first at Iowa State University and then at the University of Florida as assistant vice president and senior philanthropic advisor, where his team secured $1.25 billion of Florida's $4 billion campaign in deferred gifts and outright gifts of complex assets. Paul recently founded Plan Giving Interactive, a charitable plan giving software and consulting organization, which is an affiliate organization to Charitable Solutions, the largest national consulting firm that provides charities with risk management solutions for non-cash donations and charitable gift annuities. He's also a national board member of the National Association of Estate Planners and Counsels, which provides services to their estimated 30,000 individual members. Paul's presentation is entitled Revisiting and Refining: The Final Important Steps to Enhance the Estate Planning Process. Again, please enter your questions for Paul in the Q&A, and he will be sharing his presentation with our viewers. Paul?
I'm going to pull up my slides, and I want to start out first by thanking Maryland for this invitation to be with you today. It may surprise you to know that 60% of Americans do not have a will, and you may have already been aware of this. And many individuals cite a lot of reasons for that. Usually, it's, believe it or not, it's not the financial reasons. It's the reasons range from not having enough time to simply not wanting to think about it. And so today we're going to kind of bring everything in for a landing. I hope that you've enjoyed the first 3 sessions for today. I hope that what I provide you is a complement to that, hopefully not too much overlap, that you can take away from today to feel really confident in your estate plan going forward. As Patty mentioned, I'm on the national board for this organization called NAPEC, which is the National Association of Estate Planning Councils. And believe it or not, that organization in 2008 worked with our legislators, the House, believe it or not, to be talking about the House of Representatives this week, but the House actually passed Resolution 1499, which was this kind of adoption of National Estate Planning Awareness Week. So that's where this all comes from. And I'm so pleased that Maryland takes the time to put information like this forward. I hope that you find ours useful. So in our time for today, I really want to break it down into 3 different areas. As Patty mentioned, I want to talk about kind of refining your estate plan along the way. So in the cycle of the estate planning process, this final step is revisiting it and refining it. And so hopefully by now you've talked about organizing, assessing, and actually implementing your estate plan. This presentation delves into the importance of periodically reviewing your estate plan in doing that in a number of ways. I'm going to provide a checklist, which I believe the slides will be available to you, so you can have this checklist, or feel free to reach out to me for a PDF of this checklist that you can keep. Next, we're going to talk a little bit about some legislation in the last 3 to 5 years that has an indirect impact on estate planning. And in most cases, I think you'll find that this would pertain to you, and maybe some of this does not pertain to you. So I want to spend a little bit of time on it, though, just to cover some legislation that impacts your estate planning. And then finally, we're going to discuss the value of a document that very rarely gets discussed. And I'm really hoping that more estate planning attorneys and other advisors encourage their clients to create a letter of instructions. Let me be clear, it's a non-binding letter of instructions that you yourself can draft that would be a wonderful complement to your legally binding and enforceable estate planning documents. So with that, let's talk a little bit about the checklist. So we talked about the 3 core topics for today's agenda. So let's talk a little bit about this checklist. So I'll just touch on 2 things on this page. The first thing that I think is important to really consider, and the way that I structured this checklist is I tried to think of pretty much any type of dynamic which would cause your estate plan to need to be revisited for a variety of reasons. The first one is family dynamics, which is probably obvious to most of you, but sometimes just having a checklist in front of you to remind yourself of life changes is really helpful. So, for instance, you see all of the major life changes there, possibly new marriages, new divorces, deaths that impact your estate planning. So, and this could be related to your beneficiaries. This could be related to the individuals that you appointed to be fiduciaries within your estate planning documents. And something may have changed in your relationship with these individuals. Something may have happened to these individuals that you've appointed. And so that right there constitutes an important need to continually review your estate plan. I go through, a number of other steps on page 1 here. One of them, what is your goals? What do you ultimately want to accomplish with your estate plan? And it's not necessarily just who gets what. In some cases, it's what are my needs if something were to happen to me, and I am I'm not capable to make health related decisions, or even, similarly financial related decisions. So really making sure that you identify what your goals are, not necessarily just who your beneficiaries will be. I point to that letter of instructions below, and I'm going to, the third segment, we're going to go a little bit deeper into that letter of instructions. So I'll wait and talk about that kind of as we round out our time for today. On this page here, again, I just want to point out a few things. Earlier, I would imagine that several of the advisors were talking about the importance of your healthcare directives and your durable power of attorney. And of course, your dispositive documents, which of course would be your last will and testament or a revocable living trust. But also, one of the most important things in the estate planning process is asset titling. And so in many cases, asset titling may supersede your will. And so I'll give you an example. Let's say that you own real estate, and maybe you own real estate with your spouse or partner, and you own that in joint tenants with rights of survivorship. But in your last will, you may have indicated in your last will that you want your daughter to inherit your real estate. This could be your residence, it could be your second home, it could be other real estate that you own. And so if something were to happen to you, the asset titling would supersede what's in your will. So if if something happened to you, you predeceased your spouse then would own that real estate, sole ownership, and then his or her will would then ultimately determine the distribution of that real estate, not yours. So what seems to be always such a simple estate plan, I have a simple estate plan, it's never as simple as you think. And that's part of why just going through this checklist is really important. Let's see if there's anything else important here. I do see that hands are up, and I think we can take questions. Patty, you'll field questions along the way here. But, charitable contributions, you may think that you can't make an impact through your estate plan by leaving a charitable legacy, and often by asking your professional advisors, are there ways that I can support my loved ones and also still leave a very nice charitable legacy? In many cases, leaving behind a little bit of money so that your loved ones could even give that money away is a wonderful legacy to leave behind. And you don't have to have the wealth of Warren Buffett in order to do that. So I always put charitable planning on here. It's what I do. It's what I've done throughout my career, and encourage you to consider that as well. Okay, and the third page of the checklist, beneficiary designations. This is another very important one. I've got in here the beneficiaries and distribution of assets. Remember how we were talking about that maybe sometimes your asset titling will supersede your will? This is very important as it relates to retirement plan assets, life insurance, assets like that, where you are basically, I don't want to use the word required, but you are provided beneficiary designation forms. And I will speak from experience here. Early in my career, I worked for TIAA-CREF, and many of you are probably familiar with TIAA-CREF. And so I dealt with very thorny issues with beneficiary designations for a good part of my career. And it was surprising to me that people would automatically get enrolled to their retirement plan at work, and they never completed a beneficiary form. So by default, their estate is listed as the beneficiary. And what happens in that case is that if that IRA owner or 403B owner has a will, then the will determine who the beneficiaries are of that retirement plan. And if they don't, the state will determine it, the local court, and they will use something called the state laws of intestacy to determine who the proper beneficiaries are. During my time at TIAA-CREF, I would, on my checklist, ask individuals, should we review who the beneficiaries are on your retirement plan assets? And in many cases, the individuals were embarrassed that maybe their ex-spouse was still listed as the primary beneficiary of those assets. Yet they have this perfectly drafted will that names either their new spouse or their children, and they think that their estate plans are in order. So reviewing your beneficiary designations are absolutely one of the most critical parts of the estate planning process. Whoever is listed as the beneficiary on your 403B, whether that's at Maryland or on your IRA, those beneficiaries supersede anything that would be stated in your last will and testament or your revocable living trust. Okay. So I would encourage you to use that checklist on your own when appropriate. Maybe you need to work on some of the earlier items first that the first three speakers talked to you about. Maybe you haven't drafted your estate planning documents yet, but anywhere along the continuum that you are, it's not a bad idea to reference the checklist. But if you feel like your estate plans are in pretty good order, and you've taken all those steps in series 1 through 3 today, I would encourage you to review that checklist. Okay, now I want to switch to another topic, which is more of a legislative update. And there's a couple of things. One of them, I think, pertains to most of us because most of us have a retirement plan or we have an IRA. And our estate planning, as far as what the tax consequences are for our beneficiaries, was changed considerably through legislation that passed in December of 2019. And you may have read about this. It's called the Secure Act. So I want to talk about that. I also want to talk about the Tax Cuts and Jobs Act of 2017, which goes back quite a few years now, but it's legislation that is still in place, and it will be in place through December 31st of 2025. And that has to do more with estate taxes at the federal level. I'll also talk about estate taxes at the Maryland level if you're a Maryland resident. So let's talk about the Tax Cuts and Jobs Act first, because estate planners have long been talking about this. And so what happened with the Tax Cuts and Jobs Act of 2017 is that every person in the United States has a federal estate tax exemption, let's say before 2017, of $5 million. That means that you can give away $5 million during your lifetime to loved ones, or if you die and you have more than $5 million, you have an exemption on the first $5 million. Anything above and beyond that is taxed at a flat 40%. Okay, so if you were, again, pre-2017, if you had an estate of $8 million and you died, you had $5 million in an exemption, and then anything above that would be taxed at 40%. So $3 million would be taxed at 40%. Okay, Maryland is one of the, I would say, one of 15 states or so that actually has a state estate tax. And Maryland set theirs to be the same as the federal exemption. So in the state of Maryland, if you're a resident there, you have an exemption on the first $5 million. And again, going back to my example, if your estate was $8 million, then you would have, $3 million of it would be taxable, both, however, though, at the federal level and at the state of Maryland level. So in 2017, the federal estate tax exemption doubled. It doubled to 10 million indexed for inflation. So right now in 2023, that exemption is just under $13 million per person. Why am I telling you this? Some of you may have estates of that significance, and it's important for you to obviously know that. But the other is that in December of 2025, that exemption will go back down at the federal level to $5 million unless there's any more congressional actions that take place between now and then. So if you are building up a prodigious amount of wealth, but yet you weren't worried about the federal estate tax, you may be in a spot where you have to think about doing some very complex estate planning to possibly mitigate future federal estate taxes if that exemption does indeed go back down. So again, just wanted to share that with those, whether your estate is of that magnitude or not. Hopefully you find that information useful. Now on to something that may be more useful to all of us, because we all have retirement plans and we all have IRAs. So about 21 years or so ago, maybe even a little longer, Congress put forth a new method of inheriting IRAs where you could, instead of having to withdraw all of the money basically right away and pay federal and state income taxes, if you inherited an IRA, that they would allow you to stretch that IRA or 401k or 403b over your entire life expectancy. And this was very welcomed by people because this allowed someone who inherited an IRA to mitigate income taxes and spread that tax out over their entire lifetime. In fact, let's say that my father left me an IRA, and I could stretch out those payments over my entire lifetime. And then when I died, I could leave the IRA to my son, and he could continue to stretch using my life expectancy. But it was a generational IRA that you could leave behind to your loved ones. And it was very welcome to the estate planning process. Well, the Tax Cuts and, the Secure Act of December of 2019 basically eliminated the ability to stretch or to take that life expectancy payout for the majority of beneficiaries, and specifically for adult children. So they left 5 eligible designated beneficiaries, and those are your surviving spouse. And your surviving spouse, by the way, has the most flexibility of any other person in the world, because they actually have the ability to roll the IRA that they would inherit from you into their very own IRA. They're the only person that can do that. So surviving spouse is one of these eligible designated beneficiaries that can continue with this life expectancy payout. The other would be a minor child, and a minor is considered, I may have actually have this, I got it right here. A minor is considered anybody who's under the age of 21. Okay. However, in this case, when that minor turns age 31, they have 10 years from the time that they inherited that IRA that they would have to empty out the entire IRA in that 10th year. So by the time they're age 31, which is a very young person still yet, they would have to take all of the distributions out from that IRA. And then the other 2 here that I mentioned are individuals who are disabled or chronically ill. They would have had to have had those ailments before, or afflictions before the IRA owner passed away. And then 5th, any person who is less than 10 years younger than the IRA owner. Okay, well, that's going to rule out most adult children. So let's just say you're 65 years old and you have a daughter who's 40. Okay, so she's not going to be one of these eligible designated beneficiaries. So basically what her option's going to be is that she may be able to wait for 10 years. And then in that 10th year, she'll be required to take the entire lump from that IRA, and she'll pay all those taxes in 1 year. Okay. Or if you had already turned age 73, okay, in my example, I'm using 65, but let's say that you were over 73. You have reached what's called your required beginning date, where you have to start taking required minimum distributions. It gets even worse for your daughter, because not only does she have to empty out the IRA in the 10th year, but she has to take minimum distributions each year as rapidly as you were required to take them during your lifetime. So what went from a wonderful opportunity, if you inherited an IRA and you were wise with your finances, you would stretch those payments out over your entire lifetime. And for most beneficiaries, that opportunity is now gone. So this is where I was mentioning, if you're over the age of 73, your beneficiaries will have to start taking minimum distributions right away. They don't even get to wait for the 10 years. Furthermore, if you think about it, and I bet many of you are probably like this on the call, next to maybe your home, your retirement plan, maybe one of the most valuable assets that comprises your net worth. This is a really important asset. And so this legislative change is it should be a part of your estate planning process. You should be talking to your professional advisors about. Furthermore, you may have let's say $1 million IRA, and maybe you have a son or daughter who you realize they're not very good with money. Or maybe they are good with money, but you are concerned about the fact that they can't stretch these payments out over their lifetime anymore. There's not a lot of creative planning to work around it, but believe it or not, there's one charitable strategy that you can use that can be a good workaround for this. And you don't, even if you're not, if you don't consider yourself a philanthropist or really philanthropic, this could actually still be a very viable tool for you, at least to do a little bit of homework on. And this is called a charitable remainder trust, or in this case, in my example, it's called a testamentary charitable remainder trust. And how it works is, let's just walk through my flow chart here real quick. Let's say that you've got a married couple. They both have retirement plans from their employers. And so they would name each other first as the primary beneficiary of each other's retirement plan. But the secondary beneficiary, the contingent beneficiary, would be this charitable remainder trust. So how does it work? If you properly establish a charitable remainder trust, is tax exempt. So all the money from your IRA would flow at the passing of the surviving spouse, in my example. It would flow to this CRT, charitable remainder trust. All of it is still tax-free. And then you could set it up to pay income for, in this case, it would be your adult daughter, if you look at my flow chart, for her entire life. And you could set it up to pay her maybe 6%, 6.5%. You could pay her monthly. And she wouldn't even have to worry about the issues around inheriting this IRA from you. She would get a nice check every month. Hopefully she would remember the good deed that you did for her. And then at her demise, whatever's left in that trust, maybe there's not very much left in the trust at all, but there could be still a nice amount in there, could go to the charitable organization or organizations of your choice. So what you've done here is you've resurrected the ability for your daughter to stretch those payments out over her lifetime. And if you had a daughter that maybe wasn't that good with money, let's say, this is yet another benefit of this, because it gives her that reliable, instead of giving her a lump sum, which she's going to probably lose half of it to taxes anyway in that 10th year. This gives her a nice, reliable income, and you can even feel good about leaving behind a charitable legacy. So it's just an idea out there that I wanted to mention. There's an attorney, I got this quote from a journal that I read regularly, and he's a fantastic attorney. He says, the benefit of the stretch through the CRT may offset or outweigh the loss of the remainder interest, because that remainder interest is lost. You know, that wouldn't go to your daughter or to your granddaughter. However, it's not a loss. You get to decide what organizations that you would want to support. So I think it's a very, very viable tool for a lot of people. This just shows you some assumptions. Let's say that your daughter inherited a $500,000 IRA, and she's 50 years old, and she's going to live for, let's say, 35 years. So I've made all three of these scenarios identical, okay, in the assumptions. So in scenario one, she inherits the $500,000 IRA, and she cashes it in right away. But she's wise enough to go reinvest the money. Okay, that's the scenario. Scenario two is that she has the ability to wait for, she's willing to wait for 10 years before she draws the money out of the IRA, assuming that she even has that option. It depends on when the IRA owner passes away, but let's just say that she waits for the 10 years. That looks a lot better. And then the third option is what I just talked about, the testamentary charitable remainder trust that paid the daughter 5% every year for her life, for the rest, for 35 more years, and the remainder went to charity. the dollar amount below the dotted line is all of the income that your daughter would have received. It's almost as much as scenario 2. It's definitely more than scenario 1. And the beautiful thing about scenario 3 is that you could still leave behind a wonderful gift to several charities that are important to you while still taking care of your daughter. So I wanted to mention this because for many of us, our retirement plans are going to be probably one of our primary assets. And yet the options that the benefit that our loved ones are going to have when they inherit these retirement plans from us are pretty limited, quite frankly. The last thing I want to touch on, and I want to leave us a little bit of time for Q&A. So Patty or anybody just chime in if I'm slowing us down here. But I wanted to talk about another document that not many professional advisors talk about, and this is a letter of instructions. And I want to talk to you. I wrote a book 11 years ago called Direction Memo: How to Write a Letter of Instructions for Your Estate Plan. And I'm happy to send you a free copy of the book. Some of it is outdated from 2011, of course, but some of the principles are still, I think, true. And I started out the book with a story, and I've been married now to my wife for 23 years, going on 24 years. And when we first graduated from college, before, several years even before we got married, we had moved to Chicago, and my wife Dana wanted to get a desk for our spare bedroom, like an office desk. And I said, okay, sure. And she said, I've heard about this new furniture store that is, it's the bee's knees. Everybody's talking about it. And I remember the first time driving up and seeing those 4 words, IKEA. And I'll never forget going into the store. I saw this desk, and the price was right. We didn't have very much money. So somebody said, well, if you want to buy that desk, you got to go downstairs. So we get this box. It's definitely not a desk. It's a box. And so we load the box into our car. We go home and we open up the box, and we realized that we didn't buy a box, or we didn't buy a desk. We bought a box that had 100 pieces of all kinds of items, and we had an Allen wrench to put it together. And there wasn't even any instructions. So we agonized the entire weekend. We didn't know where certain pieces fit. And needless to say, we got into many disagreements that weekend. We finally put it together by Sunday evening with a lot of trial and error, but there were a lot of times that we were unsure if we would make it. But that's a metaphor for what happens when you lose a loved one, a patriarch or a matriarch, is that your loved ones are often searching for pieces. They're looking for your property, tangible, intangible property, even your real property. And they may be doing this with limited tools, okay? And a will or a trust may not necessarily provide the instructions or the information about what to do with those assets. A will or a trust is a good way to determine who gets what, but not necessarily what needs to be done. So I really thought about this idea of a letter of instructions because I think it's so important as a supplement to your estate planning documents, like your will or your trust, because again, the point of those documents, they're legally binding and enforceable, and the purpose of them is to determine who gets what. And, a lot of financial planning requires us to use our imagination. Many of the tools that are available to financial planners is to try to forecast, are you going to have enough money in retirement to live off of? Or how much are your grandchildren going to need to go to college? These are all things that we look forward to. They're challenging, but we look forward to them. But when you think about financial planning as well, a good advisor we'll also want to walk through the scenarios that are not as pleasant that you need to plan for and consider. When I was younger, I remember watching Willard Scott on the Today Show, and it was rare when somebody reached the age of 100, and he would make a big deal about it. If you're my age or older, you absolutely have to remember that. And now turning 100 is no longer a rare occurrence anymore. And so what's happening, however, is that healthcare is advancing so much, but our mental capacity as we age is not keeping up with it. I bet every one of you have had loved ones. I had a father who had dementia. We have all dealt with this. So these letters of instruction are not just for when you pass, but these are even more important for a period of time when you may not be able to make financial or healthcare decisions on your own. And you may say, well, the lawyers and the other advisors today talked about the power of attorney, right? The financial power of attorney and a healthcare directive. And of course, those are important because those are legally binding documents. But those documents are not going to have every detail that you would want to express your wishes. And so, nor would the attorneys want you, in many cases, to express every wish in those documents. But it's absolutely okay to have a side letter of instructions that would guide your fiduciaries as they are making these very important decisions for you. And this is especially important for women. It's important for everybody, but according to the National Center for Women in Retirement Research, 80 to 90% of women at some point in their lives will be solely responsible for all the household financial decisions. Some professional advisors, they may advise somebody after they've lost their spouse to wait a period of time before they make any significant decisions. And as we talked about earlier, laws change, the world changes, and sometimes you can't wait a year to make these important decisions. Another study by Fidelity found that 85%, they found that 15% of couples felt confident that either spouse could assume full responsibility of their finances of the household. So in other words, 85% of couples are in many cases unprepared to pass financial management on to the surviving spouse when something happens. Instead, the widow or widower is forced to react and prepare for an independent future, possibly even at the worst time. Some of the things that you could put into this letter of instruction are things like investment decisions. I remember working with somebody who had just lost their spouse, and it's not always the husband in a traditional marriage. In many cases, the wives took on the role of managing the finances. But the question would come up regularly: what would Bob do in this situation? As his surviving spouse is being now kind of pressed to make financial decisions. Well, if Bob would have written a direction memo, kind of this side letter of instructions, then his surviving spouse may have the answer to that question, or at the very least, her confidence would increase if she has some additional guidance about what his investment philosophy was. And so within my book, The Direction Memo, I have this tool called an advanced investment philosophy. And so it's really just the purpose of it is to think about what your financial values are in relation to investments. It could be something as simple as, I don't like to own individual stocks. I prefer to own mutual funds. And even a subset of that, I don't like to invest in actively managed funds. I prefer to only own index funds, or maybe vice versa. Anything like that would be wonderful instructions to provide your loved ones, especially your surviving spouse, if you're the one who controls most of the financial decisions in the household. Another one that comes up pretty regularly, unfortunately for younger families, is the loss of of a young parent, and you hope that they have life insurance, and they might, and you hope that they do, but what happens after that surviving spouse gets this one-time check that she has to use for the rest of her life now? So having just a game plan for how that money could best be used. Should you pay off your mortgage? Should you not pay off your mortgage? What should we put away for our daughter's education? Those types of planning conversations. These things you would never put into your last will. So these are great supplemental tools, despite the fact that they don't carry any legal authority. 529 plans. I've got an example of a grandfather here who did 529 plans for his grandchildren. And as you may know, with 529 plans, if you've ever set them up for your children or grandchildren, you know that you can actually change the beneficiaries on those. So what if you had a grandson who didn't go to college, but you had a 529 plan for him? Do you still want him to have that money? Or would you rather the beneficiary be changed to another one of your grandchildren who is going to college? These are all important decisions. And once you're gone, your input will no longer be there, because again, this information is not going to be in your last will and testament. And then finally, it's very rare that I see this, but in some cases, in a financial power of attorney or a healthcare directive, some states call it, sometimes you'll see final arrangements instructions in there, but it's very unlikely. So the first thing right out of the gate, I remember my wife lost her mother-in-law at a very young age, unexpectedly as well. And the first argument that the siblings had, step siblings and my wife's stepmom's own kids, is what to do with their mom. Never, and this was a highly organized woman. She was a special ed teacher. She had a file cabinet with 30 years of financial statements, all the binders from her attorney with the will and power of attorneys and everything. No instructions on what she actually wanted done. Did she want to be cremated, buried, what have you? First argument that many family members get into. This one is if you have special needs children or grandchildren. If you set up a special needs trust, you will soon realize that if you put the wrong type of instructions into a special needs trust, you could jeopardize the support that you get from the government, through Medicaid. So it's very important that you keep that trust. You structure that trust in a way that you don't really have that much ongoing control over it. But it's okay to have a side letter of instructions that doesn't carry any legal authority, that your trustee of this special needs trust can use and can be guided in making decisions for that loved one. A letter of instruction is great for deciding who should get that grandfather clock. It is an embarrassing that siblings get into fights over the assets that have really no financial value. And that happens so much. And I bet many of you have been part of that in the past. A good friend of mine, a well-known national attorney, Marty Schenkman, is a big fan of letters of instruction, and he does these for his clients. It's just very rare that you see these done by attorneys. And he says that, the fiduciaries and that your loved ones really will value this type of document that you leave behind. And I think if I could quote him here, he says that nothing fills in the blanks better than a detailed, well thought out, heartfelt letter. No trust or will gives this detail, but after you're gone, your fiduciaries will want to carry out your wishes. They need to know more than just what a sterile legal document contains. And it's that's exactly why you should write a last letter of instruction. It's tough to do. And it's tough to do from an emotional standpoint, but also because you don't know where to start. It's like a blank canvas. And so I have two recommendations for you if you're interested in a letter of instructions. One is to download my book for free. I'm happy to email it to you. And there's basically an entire workbook in there to create your letter of instructions. And in the world that we live in now, ChatGPT, what an amazing new tool that this is. You could literally open up ChatGPT and just start typing away. Just type anything that comes to your mind about what, what you would want your final remains, what your investment philosophy is, so that you could leave that behind to your husband or wife. What you would want done with those 529 plans that you set up for your grandchildren if one of them didn't go to college, all kinds of things, and it will write the letter for you. So amazing new technology that we have. This is a copy of my book. So with that, I hope I kept us on track. And these are three topics in my mind that I thought maybe wouldn't be covered primarily through one of the other three advisors earlier today. So I hope these have been good additional complementary topics that we covered. And if we have time, Patty, I'd be happy to answer questions, or I would love to hear input. So with that, I think that will kind of wrap up our remarks.
So thank you so much, Paul. We do actually have a nice list of questions for you from our viewers. I will say, though, I cannot get the idea out of my mind of the little box of IKEA wrenches that I still have after 43 years of marriage, and how we argued so much about, which piece was to go before the other. But no, I do thank you for your presentation. I think it was very complimentary to the first three. So let's get started with the questions. So the first one is, where would we find either legal or legislative wording that actually says beneficiary designations supersede wording in a will?
It's usually determined by two things. It's determined in many cases by state law, and also, believe it or not, it's in the plan administration documents. So if you have a plan through the University of Maryland, believe it or not, those types of rules will usually be written directly into those plans. Or if you have an IRA at Fidelity, Fidelity has a set of rules governing your beneficiaries. So there's really no federal law that I could think of that really points to that. It's usually based on the actual plan administrator rules.
Okay, the next question is the federal estate tax what the media often refers to as the death tax?
Yes. And that is such a, the media, I think, uses that word, and politicians use that word to obviously get attention, right? But yes, in the practical world, we use the word estate tax, and it's almost always in every state set up as an estate tax. Sometimes some states actually have something called an inheritance tax. So the beneficiary is taxed on inheriting assets, but that's pretty rare. It's usually an estate tax.
Okay, great. And the next question goes back to the IRA discussion. The person wanted to know whether or not it was relevant for Roth IRAs.
Yes, unfortunately it is. I was just asked that question last night, and it is. And some people have, spent a lot of money in taxes converting to a Roth IRA. And unfortunately, when their loved ones inherit that Roth IRA, they've got 10 years to take that money out. Now it'll be tax-free at least. So that's good. But it used to be that you could stretch it out over a long period of time, and then that growth would be even more lucrative for the for the beneficiary, and those days are gone for most people, sadly.
The next question, if I am the beneficiary for a parent's IRA who passed away back in 2012, have the rules changed for me, or am I grandfathered into the old method? And can I continue to simply take the required minimum distribution as I have been doing?
That's an excellent question. The answer is yes. If you inherited the IRA before 2020, then you would still qualify to take life expectancy payouts, even if you're not one of those eligible designated beneficiaries. Great question.
Okay. Terrific. And then the next one is, I assume a Roth IRA is different and would not need the remainder trust.
I got that same question last night as well. I spoke at the local estate planning council here in Fort Lauderdale, where I am today. I have to do more research on that. I didn't have a good answer last night. I still think that there could be value to using a Roth IRA to leave behind to a charitable remainder trust. And part of the reason why is because it would still stretch that payment out over the lifetime of your loved one. And maybe you have a loved one that that you don't want to just all of a sudden inherit a lump sum. So for that reason, it still may be worth considering it, but by far, the bigger tax advantage would be if you had a regular IRA or 403B, then you would definitely want to look into this. And even if you don't consider yourself, as I said, philanthropic, the majority of the income would still go to your loved ones. That's the beautiful thing about it. The IRS does require, when you set the trust up, that it be expected that at least 10% of that money go to charity. But as I said before, there may not be 10% left if your adult daughter lived till she's 105. But it's just required at the very beginning when you set up the trust that at least 10% go to charity. So if you're willing to live with that, it could still be a wonderful long-term benefit for your adult children.
Great. And the next question is, in order to give to a charitable remainder trust, do you have to set up a trust?
Yes, you do. Now, the good news is that the IRS in 2005 actually published the specimen documents for setting up a testamentary charitable remainder trust. The bad news is that it's not perfect. You would still want to go to an attorney to kind of iron it out. However, because I'm so passionate about that planning tool, I have been working on various ways to try to streamline that process for attorneys and for other types of professional advisors so that they can draft these documents and for them to be, compliant in a very quick period of time. So you would have to draft a trust. The trust would be dry. You wouldn't have to fund it during your lifetime. And you would set it up as to be a revocable trust, and then it would be irrevocable upon your death. So that's basically how it works. But to answer the question directly, you would need to draft a trust.
Okay. And then, so the next question is a little similar in that the person was saying in order to give to a CRT, the charitable remainder trust, do you have to set it up? But they said something about a charitable gift annuity. Not quite sure what the question is now.
Okay. Well, you could use a charitable gift annuity the same way. You could leave your IRA to a charity, and the charity would agree to issue a gift annuity for your, say, your daughter, for instance. But there's several problems with that. Let's say that you have 3 children and you want all 3 of them to inherit, from this charitable trust. A charitable gift annuity can only have a total of 2 annuitants, and the rates are out of our control because they're set by an organization called the American Council of Gift Annuities. So if your daughter was only 40 years old, her income would be very, very small. Whereas with the charitable remainder trust, you can actually control a lot better how much income that she receives over her lifetime. So if I have the choice, even though it takes a little bit of time, maybe a little bit of money, hopefully not a lot of money, I would set up a charitable remainder trust instead of a gift annuity.
Okay, terrific. And then is the charitable remainder trust limited to providing an annuity to only one person, or can you provide for multiple children?
And there we go. So the answer is yes. There's no limit on a charitable remainder trust. If you had 6 children, you could include all of them. You just have to pass that one test that again the IRS requires, and that the IRS needs to anticipate that at least 10% goes to charity. And luckily in our line of business, Patty, we have software that allows us to determine that very quickly. We don't have to crunch too many numbers.
Yeah, I'm not that good at math. So, a question similar to the previous one. The person asked if it was possible to only have one beneficiary, for example, a daughter designated, and then can there be 2 designates who would each roughly get half of the funds from their parents' IRA accounts?
Yes, you can dice it and slice it any way that you want. You could, if you had an adult daughter and a grandchild, you could probably find a way to do that so that it's paying to your daughter for her life and maybe at least for a term of years to your granddaughter. If you, as I said before, you could have 3 beneficiaries, and you could say, I really love one of my kids more, and they're going to get half, and then the other 2 have to split the other half, 25% each. You could do that too.
Okay. And then what are the transfer tax rules for a 401k or pension?
Well, the good news is that if your entire estate is under, well, right now, remember in 2023, it's $12 million. So if your estate is under $12 million, there's no federal estate tax. Okay. Maryland's is still at 5%, or I'm sorry, $5 million.
Okay.
Yeah. However, what your beneficiaries will face is income tax, both at the federal and the state level. And why did Congress put out the Secure Act in 2019? Because they want revenue from inherited IRAs faster. They want money faster. Okay. It's an actual sneaky tax. And so the whole idea of a testamentary charitable remainder trust is just to resurrect the ability to take that life expectancy payout. So to answer your question, IRAs don't necessarily have estate taxes as long as your entire estate is under those thresholds.
This one feels a little bit, I'm even having trouble reading it, but it says, for estates in Maryland that total less than $1 million, is the filing of federal and state estate tax reporting mainly for governmental record keeping and not for determining the amount of tax due from the estate, given the $12 million and $5 million thresholds?
Yeah, some states have these, if your estate is under a certain dollar amount, you can expedite the process. You don't even have to file certain state or federal returns. If you have a certain, under a certain threshold, you will also expedite probate more quickly as well. But yes, generally speaking, your executor would only need to file those returns So just like you file your income tax return on an annual basis, just so the IRS has the right information.
Great. And then back to the charitable remainder trust, how is the payment amount determined?
So the payment amount is determined by you. You can decide, I want my daughter to receive 6% or 6.5%. Now, remember, if you pay her too much and she's only 50 years old and we go through a deep, recession, or she lives a very long life, you could literally the trust could eventually run out of money. So you don't want to have too high of a payout rate, but the minimum legally required rate is 5%. So for your average 50-year-old beneficiary, adult child, I would say 5.5%, 6% is a prudent payout to pay them out over their entire lifetimes.
So the person says, what if I have 7 children?
Well, I hope you have 7 IRAs. But no, again, you can add them all to it, but you just have to make sure that it would pass that requirement that 10% go to charity. Okay. And any professional advisor could help walk you through that, or of course experts like Patty Wang or other types of philanthropic advisors can provide that information as well.
Okay. And our last question is, how do we get your free book?
I will email that to either you or John, and then you're welcome to post it on the website, or however you want to make use of it. Okay. I'll send you a PDF.
Sure. Well, all of our viewers can rest assured that we will determine a way to get that to you post-conference. So Thank you so much, Paul, for your presentation. I think it was the little cherry on the top of the ice cream sundae to a wonderful series of sessions today. Thank you so much.
It was an honor to be with you, and thank you for all joining today.